How does criminal court work in Washington state? Are you interested in that subject? Do you or a loved one have a criminal case that just happened? Well, if so, this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Linwood, Washington. I have a law firm that's been defending people charged with crimes for more than 20 years. And let's face it, if you've never been involved in the criminal system, one of the scariest things there is having no idea how it works. So in this video, I'm going to cover how the criminal justice system works from the client's point of view. That's from the point of view of someone accused of a crime. And so if you find this video helpful, please like and please subscribe because it helps get information out there, and we need more information for everybody. So I'm going to just jump right into it. How does the criminal system work from the point of view of someone charged with a crime? Well, I'm going to start with the situation where a person has been charged with a non-felony crime and they have a court date right away. That's usually going to be a city case, a case that's a non-felony that happens within the city limits of a city. Mill Creek, Seattle, Shoreline, Edmonds. In those cases, you're going to be charged with the crime right away. And the first court date typically is called an arraignment. And an arraignment, that is where the defendant, the person charged with the crime, is informed of the nature of the charges against them. They're told what the maximum penalties are, and they're asked to enter a plea of not guilty. There's usually going to be a prosecutor there. That's the person who represents the government who's trying to convict the defendant. There's going to be a judge, and oftentimes there'll be someone standing in as attorney of the day for the defendant at a first appearance at an arraignment. Sometimes there's not. So once a not guilty plea is entered, the prosecutor gets to ask the court to impose conditions on the defendant while the case is going on. And the case is going to go on for months and months and months. So these conditions matter. So in the worst case, a prosecutor can ask the court to make the defendant post bail or bond to try to protect the public. So if the court asks the defendant to post bail or bond, that means they need to pay money to stay out of the jail while the court is going on. And we have a video on how bonds work, and you can search it on our channel, and I'll also link to it at the end. So if the court does order a bond, that means if the defendant doesn't pay the bond, usually they might have a day or so to do it. Sometimes they'll take them into custody right away. If they don't pay the bond, they have to go to jail. If they do pay the bond, there's going to go on through the court process out of custody. Other things the prosecutor might ask for at arraignment as conditions of release could be no contact. And that's one of the worst things we see in domestic violence cases is no contact. Hey, you're accused of assault. Maybe your boyfriend is the victim and your boyfriend does not wish the court to order you, the defendant, not to have contact with him. But yet oftentimes the court does order that over the objection of the defense. And that's because the court believes they're trying to protect the alleged victim from the defendant. They can order you not to drink. They can order you not to drive without an interlock in DUI cases, things like that. So it's important that you have an attorney, if possible, at that arraignment. So after the arraignment, we move on to phase 2 of the case, and that's called a pretrial hearing. There are a whole lot of pretrial hearings as the criminal case goes along. How I explain it to our clients is as follows. Think of a pretrial hearing as a way to force the parties, that's the prosecuting attorney and the defense attorney, to remember and realize that there's a case that exists and we need to move it towards a resolution or towards a trial. So a pretrial hearing is a little bit what it sounds like. It's a hearing prior to a trial. And hopefully we never have a trial, but at the pretrial hearing, you're not going to see any police officers. You're not going to see any victims or witnesses. You're going to see 40 other people, maybe on average, that also have a pretrial hearing that day, defendants. And you're going to see a judge, the prosecutor, and your own attorney. So the judge will call the case. An attorney for either side will speak about what's going on with the case. Hey, we need some more time, or hey, we've reached a resolution, or hey, we need to argue about this motion later. And then that's it. You might be in front of the judge for a minute, and you're probably not going to have to say anything about the case. So, make sure you have your attorney. Your attorney will do the talking for you. So the most common outcome of a pretrial hearing is another pretrial hearing because we have multiple continuances and multiple pretrial hearings until the case either resolves by agreement or ends up at a trial. So arraignment, pretrial hearings, lots of them, and then finally what I'd like to call, it's not an official court hearing, but resolution by agreement or a trial. So if a case is resolved by some type of agreement, by a dismissal, by a plea, by a stipulated order of continuance, we have a video on that too, what that means, it will often happen at a pretrial hearing. And in that case, there's going to be paperwork that you'll go through ahead of time, and the judge is going to ask you a lot more questions about if you understand it, things like that. Sometimes it'll resolve at a disposition hearing. Some courts want to speed up the pretrial calendars, and they'll put you on a special calendar that takes longer. When I say calendar, that means a date with a whole bunch of defendants in court. They might put you on a disposition calendar to basically do like 5 or 6 resolutions at once in one day for different people. Occasionally, you'll end up at what's called a motion hearing. In some cases, your attorney will need to file motions, which is legal arguments to either throw out, suppress some of the prosecutor's evidence, or to even throw out the case, motion to dismiss the case for like an illegal stop in a DUI case. And a motions calendar is much different. In that case, you'll often will see the police officer, and there will be testimony, and your attorney might present their own witnesses to try to make the legal arguments to either help your case or make your case get dismissed. So for the final thing you might see, we've had an arraignment and a pretrial, a bunch of pretrials. If there's not been a resolution by agreement, there might be motions, and then finally a trial. The most common trial is a jury trial. A jury trial for a non-felony has 6 jurors, and it's going to go a little bit like what you see on TV. Imagine a 1 or 2 or 3 or more day experience where the prosecutor and the defense attorney conducts voir dire and selects jurors for the trial, and then basically there's a whole bunch of witnesses that testify, and you get your side a chance to present witnesses or even testify yourself, and then a jury decides if you're guilty or innocent. And let's hope not guilty is what they come back with if you're on the defense side watching this video. So that's how it works if you have a charged case right away. Now, the second type of case ends up in the same way but starts differently. If you get arrested for a felony, or you get arrested in a non-city where a sheriff or a state patrol arrests you, you're probably not going to go on to an arraignment immediately. An arraignment is, again, the first court hearing after a prosecutor files an actual charge. So if you got arrested for a felony, police officers cannot charge you with a felony, they can only arrest you. Or if you got arrested by a sheriff or state trooper, those type of officers, based upon how broad their jurisdiction is, generally also cannot charge you with a crime. They can only arrest you. And so in that case, you're going to have what's called a first appearance and a second appearance, where the court is going to look at those conditions, sort of like at the arraignment, and tell the prosecutor you have 3 court days to file an actual criminal charge against this suspect who's been arrested but not charged yet. And if you don't file a charge within 3 court days, all of my conditions that I've imposed are going to evaporate. And I've got a video on this too about what to do if you're arrested for a felony. I'll link to that in the description as well. But the big mistake people make is you go to the first appearance and the judge says, okay, here's your conditions of release, pay some bail. I'm going to set you a second appearance for a couple days later. You show up at the second appearance, or you don't have to go to the second appearance, and the prosecutor does not file a charge by then. So your case is dismissed. Yay! Well, that doesn't mean your case is dismissed. And that's the big mistake people make. It means that the probable cause hold was dismissed. The prosecutor still has your case, and they're still going to look at filing your case, but they have up until the statute of limitations to make a determination about whether to charge you or not. And guess what? We've got a video on that too. So I'll try to link to that in the description. So If that's your situation, you need to get a hold of an attorney as well, because sometimes us attorneys can help you avoid getting charged. And if we can't help you avoid getting charged, we can at least help you do some things to help your case, and most importantly, give you some peace of mind while you're waiting and waiting and waiting with this big thing over your head and you're just wanting to get it over with. So that is the general process of how court works. If you find yourself charged with a crime, please feel free to give my office a call. Again, my name's Lance Fryrear, and I have a law firm in Linwood. We've been defending people charged with crimes for more than 20 years. We've seen it all. We've probably done it all. And if you give us a call, we're going to listen to what happened. We're going to tell you what you need to do. We're going to make it so you can sleep again at night, and we're going to be there for you. Thank you.